I certainly have never been given certainly a more gracious introduction. I don't think as gracious an introduction. And it really actually makes me cry, as does the subject of my lecture. Makes me cry. When I read over the article that I must submit to the law review, it made me almost as sad as the beauty of that introduction. Now here's the setup for what I want to talk about and what I'll ultimately publish an extremely gassy and scholarly account of. My starting point is that the interesting issues in public law today, or among the most interesting, are what we would call clashes between gay equality, equality for lesbian and gay citizens, and religious liberty. And there are a number of situs of this clash, and let me just mention several of them you probably know about from your own casual reading. One kind of situs is at a fairly general level, and these are what I call no promo homo arguments. And these are arguments often in the political sphere, sometimes in the legal sphere, that promoting so-called immoral homosexuality, immoral from a religious point of view, will undermine God's order and make the job of religious parents much harder. This was arguably the big argument in the California Prop 8 case in 2008, where the voters of California, by 52%, overrode the California gay marriage decisions. It also was traditionally the religious opposition to sodomy law reform by the Catholic Church in the Northeast, by the Southern Baptist Church here in the South, and by the LDS, or the Mormons Church in the West. A second kind of argument, and you see this particularly in constitutional cases, not just in the political arena, are what I would call forced association arguments. And that's the argument that anti-discrimination laws either will or have had the effect of forcing religious persons to work, associate, and maybe even live with quote-unquote homosexuals whom they consider pollutions. This was the main argument in the initiative almost a generation ago in Colorado in 1992. That was the focus of the Romer versus Evans case you might have read. It was probably the main argument in Boy Scouts versus Dale, which is a more recent case, where the Supreme Court said that the Boy Scouts could exclude openly lesbian and gay scoutmasters. The assistant scoutmaster in question, when he came out of the closet, was let go by the Scouts based upon the idea that we don't want to be forced to associate with open homosexuals because that would be considered polluting from the point of view of parents and some of our own people. And then the third kind of argument, which I think is the most powerful one from a public law point of view, is that in some cases, equality for gay people will mean censorship of religious identity. And you see a lot of these cases today, and I think you're going to see more of them as there are more anti-discrimination laws that are adopted, and religious people come out of the closet as anti-gay. So the objection here is that politically correct state programs will have the effect of censoring religious expression that reaffirms traditional sexuality. One locus for this kind of debate is the T-shirt wars that you see in California and Illinois and states like that, where there will be a tolerance day sponsored by the high school or the junior high school, and some students who want to express their own identity will have such things as homosexuality is shameful. That's one of the Ninth Circuit cases that's come up. There's a milder case in Illinois where happy not gay is what the student wears on the T-shirt. Kind of cute. The Christian Legal Society case now before the U.S. Supreme Court is going to raise this case, which will be decided this term by the justices. Now, part of my argument is that these clashes between equality and liberty are not new. And all three of these kinds of clashes have explicit parallels in the race cases of a generation ago and even today when some of these arguments are still made. So to give the close parallel between what I suggested before and the race cases, here are the following. Among the arguments against integration and different race marriage were the no promo racial mixing. That in the South, it was a very common argument that either integration or different race marriage should not be allowed by the state because it would promote so-called immoral miscegenation, which will undermine, not underline, but undermine God's order and threaten families. And this literally was the argument made in Loving versus Virginia. The district trial court accepted that argument and said that we're going to uphold Virginia's miscegenation law because it reflects God's will that the races not mix. These were not only pro-segregation arguments, but these were also notable arguments in favor of slavery in the 19th century. A second kind of argument, very common, were forced association arguments, and here I'm going to have to invoke the Yale Law School. It was argued in my generation that anti-discrimination laws, race anti-discrimination, not sexuality, will force religious persons to work, associate, and mix with quote-unquote polluting races. That argument was made on the floor of Congress in the 1960s in opposition to the Civil Rights Act of '64 and the Fair Housing Act of 1968. It was also made by my colleague at Yale, Robert Bork, as a reason to oppose the adoption of the '64 Civil Rights Act that he made from his pulpit at the Yale Law School. And then thirdly, there are arguments made that anti-discrimination laws, even in the race area, will censor religious identity. The argument was that the civil rights state will censor religious expression that reaffirms traditional race-pure sexuality. And this argument continues today because the main side of this argument, or at least the one that's most available to us, is the cross-burning cases. What can be a more literal wedding of religion, racism, and expression than burning a cross? And these cases still do come up at all levels. Now, the claim that was made in Amendment 2, that's the Colorado Amendment in '92. In Prop 8, that was the California proposition in 2008. And in the Christian Legal Society case, which involves whether the Hastings Law School, a public law school, has got to allow the Christian Legal Society to exist as a state-sponsored student organization, even though the Christian Legal Society does not include in its members what they call unrepentant homosexuals. And the school won't let them do that and be an official state organization. The argument that is made by the defenders of Christian Legal Society, by the Prop 8 people, and by Amendment 2, is that civil rights analogies of the sort that we had in the prior slide do not apply in these cases. And the main claim, or at least a major claim, is because religion is all about rules of sexual morality, and religion is not about racism. The argument is further made that religion condemns racism, as it indeed should. It is the homosexuals who are racist by making these godless parallels. Now, that's a bit of a stretch, but that is what is believed by many of the people, that this is not only an incorrect argument, it's kind of an offensive argument. And not just white people. I mean, many African Americans and people of color join white traditionalists in arguing that the racism parallel is a bad parallel, and indeed it's an insulting parallel. The point of this lecture is that the foregoing claim, i.e. the claim that is in bold, is false as a matter of theological history. To the contrary, I want to show that there are many parallels between religion-based support for race discrimination and for discrimination against sexual and gender minorities, in other words, for both. Let me start, if I can, with race and religion. Now, the arguments that I'm going to present, I do not present, and I can't imagine anyone will construe them this way, as a Eskridge-approved or Dean-approved interpretation of the Bible. I'm going to suggest, however, these were arguments and interpretations that were widely accepted in the South, and indeed widely are still accepted in certain parts of the South. Now, here are three arguments, and there are lots more Bible passages I could talk about, but these are probably the most important ones. The first is what we call Noah's curse, and this gives us part of the title of the lecture. The Noah story, as you well know, involves the flood, but the part of the story I'm interested in is after the flood, and many of you might not know about that. You might not know that Noah had at least 3 sons, Ham, Shem, and Japheth, and that after the flood, Noah planted, as the Bible tells us, a vineyard. Noah harvested the vineyard, and Noah became inebriated and passed out. Now, and here's where we get the punchline of the story. After Ham, one of the sons, saw his father passed out and naked, he reported it to his brothers, Shem and Japheth, and the brothers went and covered their father in his nakedness and his shame. The father, upon recovering his senses and the will of the Lord, said the following. And my quotations are I think, all going to be from the King James Version, which is a fairly standard Protestant version of the Bible. Cursed be Canaan, who was Ham's son. A servant of servants shall he be unto his brethren. Blessed be the Lord God of Shem, and Canaan shall be his servant. God shall enlarge Japheth, and he shall dwell in the tents of Shem, and Canaan shall be his servant. And there are the precise references in Genesis. The sons of Canaan, and indeed the sons of Ham, according to Christian lore, were the originators of the races in Africa. The children of Japheth, according to Christian lore, were the progenitors of the Europeans. And I guess Shem was the father either of the Semites or maybe more generally people who populated Asia. The interpretation of this passage, or an interpretation of this passage, was that this passage not only supported slavery, but directed slavery. That the children of Canaan, who were the Africans, were directed by the word of the Lord to be the servants, i.e. the slaves, of the descendants of Shem and Japheth, i.e. The Semites and the Europeans. This argument was widely and maybe universally believed in the South by Southern Baptists, by many Methodists, by most Presbyterians in the 19th century, both before and after the Civil War, as not biblical support for slavery, but a biblical admonition that slavery was required by the Lord's word. Let me give you another story. And again, it's going to be a familiar story, but with a punchline that might be unfamiliar to you. And that's the story of Nimrod's hubris. Ham's grandson was Nimrod, the king of Babel. Now, you probably have heard of Babel more than you know about Nimrod. As you remember, one of the great Babelian projects, and perhaps the only one that I could name, was to build a great tower whose ambition offended the Lord. Because I suppose the tower was to reach into the heavens, which was beyond the legitimate ambition of humankind. To thwart Nimrod's project, according to Genesis, the Lord instilled in the builders different languages so that the men could no longer understand one another, and what that means is that the project fell apart because, like law faculties, it's like herding cats if you cannot understand one another's languages. And then, according to the word of the Lord, God then scattered them abroad from thence upon the face of the earth. Now that's from Genesis as well. Now the lesson that was learned from that in the 19th century, primarily again Protestant theology, and I'm primarily thinking of Baptist theology, but also Presbyterian and Methodist theology in the 19th century. And indeed, I grew up as a Southern Presbyterian, and the founder of the Southern Presbyterian Church, Reverend Palmer, these were his arguments for slavery and against mixing of the races. And the argument that Reverend Palmer and many other theologians of the 19th century drew from this was that the races should not be mixed, that God had affirmatively dispersed the races. Now here language is being used as a synonym for race. And what God has dispersed should not be reunited by man, and indeed the carpetbaggers' effort to do this after the Civil War was partaking of the sin of Nimrod, i.e. hubris. So this was an argument that even after slavery ended was a way of extending the Noah's curse argument about slavery to support explicit apartheid. In other words, even if there were no longer slavery in the United States, there could still be no mixing of the races, no apartheid. And then to complete the unholy circle is what I call Isaac's blessing. And that's an argument about miscegenation in particular. So you could say, and I think religious people did say, and by the way, this by no means exhausts the religious arguments, but you could say from Noah's curse and Nimrod's hubris, if you believe these as foundational, that they had a corollary, the biblical disapproval of sex or marriage between different races. That would seem to be a corollary. Very often, and I will tell you on the floor of the Senate, this argument was used. This idea was confirmed by Isaac's blessing upon his son Jacob. Now, if you've not read the Bible, Isaac is the son of Abraham. In fact, Isaac is the one who was almost sacrificed. Abraham was willing to sacrifice Isaac. No great favor to Isaac, but to the Lord. And just before the sacrifice took place, the Lord sent, I think, a sheep or some such instead, who was able to take the place of Isaac, to the benefit of not only Isaac, but also Jacob and Esau, who were Isaac's children. So when Isaac blessed his son Jacob, here is what the Bible says that he told him. Isaac called Jacob and blessed him and charged him and said unto him, Thou shalt not take a wife of the daughters of Canaan, according to Genesis 28:1, i.e. the African descendants of Ham. So again, this is a direct biblical invocation, according to the supporters of this, of the idea that not only slavery required and mixing of the races not required, but you're specifically forbidden at least to marry someone, not just of a different race. The specific referent, as it was read, was the descendants of Canaan, who was the parent of the African race. Now, in the written article, I go through somewhat laboriously, religion by religion, and provide a theological history of how these foundational Bible verses were used. And as you see, all of these verses from the Old Testament, so this is not just Protestants, of course. These verses also are scriptural for Catholics and for Jews. And the issues that I look at, and I'll give you, so that I don't take all afternoon in the lecture, though I easily could, and it's one interesting to look into. Here is a brief tour d'horizon of how these biblical passages were invoked by different religions, because part of the story I'm telling in this article is a story of heterogeneity among religions. The religions do not march in lockstep. Though it is the case that the major religions in the South, by which I'm thinking about the Baptists, the Methodists, the Presbyterians, and even the Catholics, both support slavery and apartheid, the most surprising story is the Catholics. Because as far as I know, and have been able to tell, the Roman Catholic Church in Rome and the official Catholic doctrine did not in the 19th century approve of slavery and did not in the 19th or 20th century approve of apartheid. Yet it still was the case that the bishoprics in the United States, specifically in the southern United States, did support both slavery and apartheid for biblical as well as practical reasons. So some of these religions are quite complicated. The simple story is that before 1866, there was wide theological support for slavery based upon the verses that I've given you. And when I have a no followed by a yes, as in the case of the Mormons, the Presbyterians, and Methodists, it means that these faiths, like John Wesley, the founder of Methodism, was opposed to slavery. He did not agree with any of these verses. John Wesley certainly read the New Testament and Christ's admonition to be inclusive and the brotherhood of man. Wesley read those verses as utterly antithetical to slavery. But the Methodist Church, in around the time of the Civil War, the Southern Methodists actually split off from the Methodist Church on that very issue and rejected the traditional teachings of John Wesley. Ditto for the Presbyterian Church, led by Reverend Palmer. For the LDS Church, Joseph Smith, the founder of the Mormon faith, did not believe that slavery was supportable in the Bible, but his successor, Brigham Young, apparently did. And indeed, Utah was a slave territory. It was not a state at that point, before the Civil War, due to the Mormon influence. The Catholics, I put no question mark, because official Catholic doctrine said no. Southern Catholics said yes. And Reformed Jews were always a no. Similar for segregation and apartheid before 1954. Now, these are obviously key dates. 1866 is the 13th Amendment. 1954 is Brown. Okay? So I'm thinking about how these religions believed before these landmark legal events. Baptists, yes on segregation. They believed in it. Matter of faith. Mormons, yes on segregation. Word of God. The Presbyterians, as a legacy from Reverend Palmer, were a yes for most of the 20th century. By 1954, they were moving toward no. There was significant Presbyterian support for Brown and enormous Presbyterian support for the Civil Rights Act of 1964. Same is true of the Methodists. The Catholics, I have acquiescent for part of that period, but then they moved more firmly toward no. I would say earlier than the Protestant religions. And again, the Reformed Jews, I use those as like a holder, like they give good answers to everything from my point of view. Well, I would put some religion in there that had good answers. The marriage bar, a similar sort of pattern. Race and religion. during the period of, say, my lifetime, which is quite long, and before, Professor Kurtz's lifetime as well. Here were the liberty arguments that they made. The abolitionists challenged slavery. And remember, don't forget that the abolitionists challenged slavery partly on religious grounds. That the opposition to slavery was in very significant part religiously inspired, religion being easily on both sides of this issue. But the abolitionists, for various reasons, challenged slavery. And in response, there were religion-based claims that slavery is important to God's order. And the Presbyterian and Methodist churches did split over this issue because they viewed slavery as not only required by the Bible, but as an important part of God's order. And abolition would upset the free society created by the Declaration of Independence and the Constitution. That's in the slavery period. In the civil rights period, let's say the period from the 1920s to the 1950s, when the civil rights movement, the NAACP Inc. Fund, chief among them, but later the Southern Christian Leadership Conference, again, religion, challenged apartheid. Among the chief arguments against the claims of the civil rights movement was the religion-based arguments that associational liberties are being sacrificed. And removed Professor Bork, who was making a secular argument for that. Instead, look to the senator from my state. I grew up in West Virginia, a quasi-southern state. Senator Robert Byrd, later the majority leader of the Democrats. And every day that man wakes up, he's setting a new record for longevity in the Senate. The longest-serving senator in U.S. history is Robert Byrd. And he opposed the Civil Rights Act in 1964. But this is not a deep Southern senator. Y'all's senators, Russell and Talmadge, were not nearly this polite, honestly. Okay? Robert Byrd, who was a moderate by Southern standards, opposed the Civil Rights Act of 1964, a foundational anti-discrimination statute, based upon literally Noah's curse and Isaac's blessing, which are quoted in the congressional record. Okay? And to give you some of the flavor, from his point of view, anti-discrimination rules, such as these in the 1964 Act, would imperil the liberties and freedoms of religious citizens. And then after this is passed, and I could go on, he went on for many pages using these arguments, as did other Southern senators. After anti-discrimination and hate crime laws have actually been enacted, religious citizens have still raised First Amendment claims that they should not be prosecuted under these laws because they were merely acting their religious beliefs. And then the final set of racist laws to fall, to my knowledge, are the miscegenation laws, the laws prohibiting different race marriage. And the civil rights challenges, again to this, also again based partly on religious grounds, stimulated religion-based claims that religious liberties are being infringed. And Loving versus Virginia is a wonderful and horrible example of that. In 1963, when the trial judge ruled in the case, this is before the 1964 Act, the only reasoning that the trial judge used, to our knowledge, because it's repeated in other opinions, is the Noah's curse idea, and the idea where he got from I don't know exactly where, that God created the three races, and God meant for the three races to be segregated. I don't know whether it was from Nimrod or from Noah or where, but it was God, apparently, who was the author of that. And not only did the trial judge uphold the Virginia miscegenation law, but the trial judge says, we are going to convict you. It was criminal law. So the Lovings, who were legitimately married in D.C., they were a different race couple, Mildred Jeter and Richard Loving. They were legitimately married in D.C. That was a crime for a married couple legitimately in D.C. to live in Virginia. That was a crime. And the trial judge says, I'm going to sentence you to 25 years in jail. Or I'm going to sentence you to jail unless you agree to leave Virginia for 25 years. Which the Lovings prudently agreed to do. Okay? Though they could still take their appeal, right? You know, he was racist, but he was not unjust, maybe, in that sense. Then it goes to the Virginia Supreme Court. The Virginia Supreme Court upholds the law, but with none of the religious stuff in, I think, 1966. So this is after the 1964 Act. And after the Voting Rights Act of 1965. They uphold it in 1966 based upon precedent. In other words, Virginia Supreme Court had ruled on this issue before, indeed in the 50s. And they said, we've already ruled on this. We follow precedent. We're just going to reaffirm the precedent and say nothing more. And they vacated the 25-year nonsense, showing that a little bit of common sense had seeped into the Virginia bureaucracy since 1963. And then by the time it reaches the U.S. Supreme Court in 1967, which of course is right in Virginia, or at least next to Virginia, which was once part of Virginia, between Virginia and Maryland, what it intervened was not just the 64 Act, but the Voting Rights Act of 65, and in the 66 elections, the two leading racial segregationists in Virginia were defeated. Willis Robertson, the senior senator in 66, racist, father of Pat Robertson, whom you've heard of, defeated in the primary, and Howard Smith, who had sought to preserve segregation for years as head of the Rules Committee, defeated in the primary. Segregationists all over the South lost money to Republicans in the 1966 elections. And after those elections, which were kind of a ratification, even in the South, of the ideas of the Voting Rights Act and the Civil Rights Act, the U.S. Supreme Court felt it was safe enough to overturn miscegenation laws. Yet this did not end these challenges. The challenges still kept being made, and maybe they keep being made to this day. The most famous series of cases are the ones involving Bob Jones University. Bob Jones University in North Carolina, I believe, or South Carolina, a university which did not allow people of color as students for most of its history for religious reasons. Noah's curse, the whole business. This is in the 1960s and 70s, and Noah's curse is being used in briefs as justification for sincere religious opposition, etc. So they not only exclude people of color, but they say we should also be subsidized by the federal government as charitable institutions. And they had some very good statutory arguments for that. The Nixon administration, Ford administration, the Carter administration said, no, we're not going to subsidize openly racist institutions anymore. Bob Jones responded by changing its policy. Well, we now don't discriminate based on race. All we say is you can't date outside of your race. So we'll allow students of color, but no one can date you, except other students of color, I suppose. So that was their new policy, updated racism. And the Reagan administration supported them. So as late as the 1980s, the President of the United States was supporting the idea that segregated, or whatever you call the miscegenation thing, institutions should be subsidized by taxpayer dollars under this charitable exemption thing. Okay? Supreme Court ultimately disagreed, but that argument still has not entirely died down. Now that gives you a flavor, and believe me, it's only a flavor, a small taste of the pervasiveness of religion in opposition to equality laws in the race area. Now let me give you a shorter tour d'horizon, because more of it I presume you're familiar with, on homosexuality and religion. And again, there are a number of passages that might be pertinent, and I'm going to try to give you the main ones. The one you've probably heard most of is the Levitical condemnation. There are literally hundreds of purity rules in Leviticus, and I urge you to read that book. If you want a life plan, read that book. And I do notice that some of you are wearing cotton polyblends. So that's the primary. Now notice that the Levitical condemnation does not apply to women, sex between women, or as far as I can tell, sex between a woman and a man, but certain kind of sex between men. St. Paul updates that. St. Paul of the New Testament, in various letters that he wrote to Christian congregations, gave them rules to live by and to exclude by. And in his letter to the Romans, St. Paul taught, among other things, and here I'm quoting from the Revised Standard Version, which I think is more colorful than the King James Version. Paul says in 1 Romans verse 26 that the dishonorable passions of women as well as men, so this we get women in, who exchanged natural relations for unnatural, were displeasing to God. And, in a later verse, would be visited with God's judgment on the bodies of such sinners. So I call this Paul's admonition. And if you want the best Bible passage, because it's one that maybe could apply to lesbians as well as to gay men, maybe that's the one. But St. Paul also had a lot of advice on marriage. And for those of you who are thinking of marriage, or maybe even have done it once or twice, you might want to read St. Paul, who is on the whole not a great fan of the institution. He warned the Corinthians that neither fornicators, nor adulterers, nor effeminate, nor abusers of themselves with mankind can inherit God's kingdom. And then he has a short diatribe against any kind of sexual interaction. But he does recognize, since he was a pragmatic saint, because human beings are filled with passion, he gave them the following advice. Let every man have his own wife, and let every woman have her own husband, says the Lord. Now, those passages, and there are a few others, but not all that many, frankly, those passages can be invoked by religious persons of the various religions. Though, again, remember, for Jews, the New Testament stuff is not going to be admissible. You have to stick with the Levitical stuff if you're going to have condemnation in that particular faith. Now, how have they been interpreted? Well, in most of the 20th century, they have been interpreted as requiring laws against consensual sodomy, including here in the state of Georgia, where you might be interested. It is a crime. It's not enforceable anymore, but it is a crime for two people, not two gay people, but two people, to have oral intercourse. And it is a mandatory 1 year in jail for you. So you might want to think about that. I'm not kidding. But I will also tell you it's not enforceable anymore. But it is still a crime. It's a felony in the state of Georgia for consenting adults in the privacy of their homes to have oral intercourse. Maximum sentence is 20 years if it were enforceable. And the minimum sentence is 1 year. In other words, the judge would theoretically have no discretion to give you a lesser sentence than 1 year. And major arguments in favor of sodomy laws for most of the 20th century were these religious arguments, particularly, I suppose, the Levitical argument, to some extent, Paul's argument in Romans 1. And indeed, before Bowers and Hardwick, your state, there you are again. You'll appear quite frequently. Before Bowers and Hardwick, the Baptists, the Mormons, and the Catholics were all on board, not just that sodomy was a sin, but that it is a sin that should be enforced as a matter of state violations. Presbyterians were kind of off that boat. Methodists, Episcopals, Reformed Jews, and Unitarians generally not in favor of using civil or criminal law as a way of enforcing whatever you said about the Levitical commands. St. Paul, in particular, was used before the Lawrence case for civil exclusions of gay and lesbian people. So your Attorney General in 1986 successfully defended your sodomy law. Well, subsequently in the 1990s, your Attorney General defended the proposition that an open lesbian was, by her own openness, disqualified from serving as a lawyer in the Attorney General's office. And that was upheld also by the courts, that per se exclusions, simply because of your orientation. By the way, this was a woman who was getting married, and this, I think, was the problem. That according to Dean Kurtz, the Attorney General's office did have lesbian and gay attorneys, but none of them was quite out of the closet that way. So the honesty of the attorney triggered the exclusion, presumably because she was going to be an unrepentant violator of the sodomy laws. Apparently at the same point where the Attorney General himself was engaged in criminal violation of the adultery law, and maybe the sodomy law as well. So a little bit of irony in the state of Georgia, these exclusions. But again, and by the way, adultery is in the Bible, and indeed it's one of the commandments. Look it up. So a little bit of like Southern irony there. But these same Bible passages, forgetting about the adultery stuff, right, were the bases for the Baptists and the LDS people, the Mormons, to endorse, to favor that lesbian and gay people should be excluded from civil employment, from the military, etc. The Baptists still believe that to this day. The Mormons, I think, are a little bit more ambiguous. Interestingly, the Catholics by 2003 were off of that boat. And in fact, I think in the 80s and 90s, by the 90s, the Catholics have withdrawn from any support for civil discriminations based on sexual orientation. And indeed, there are lots of Catholic documents that actually denounce discrimination based on sexual orientation as something that is actually not religiously inspired and is contrary to religion. And then you get the litany. The big issue today is gay marriage, obviously. And I don't have a date there because we don't know when this issue will be resolved, if it ever is. And as you see, most religions, including the Presbyterians, and I think on the whole still the Methodists, do not favor same-sex marriage and do believe that same-sex marriage is prohibited either by St. Paul or Genesis or somewhere in the Bible. There's opposition to same-sex marriage because the Bible treats marriage as one man and one woman. Although it does better than that, it often treats it as one man and lots of women. You know, Solomon and David being prominent examples of that. Okay? And then the Episcopalians, Reformed Jews, the Unitarians, admittedly very tiny numbers of people. You know, if you want to talk about the big religions in America, the Baptists and the Catholics are it, and the Mormons might be the fastest growing. So you notice those are the entrepreneurial religions, you know, still pretty anti-gay. The little teeny-weeny boutique religions, not so much. So don't let the chart fool you in that particular way. And then you see, therefore, if this is the lay of the land, which I think it basically is, again, religion is heterogeneous, but there you have it. There are going to be clashes between anti-discrimination laws protecting gay people and religious liberty of various sorts. And you see the same thing that you saw with race and religion. So the homophile challenges to sodomy laws provoked religion-based claims that criminal sodomy is important to God's order. Now, don't laugh at that, because these were very serious claims and ruined the lives of thousands of people. And maybe even, not in your lifetime, but in Dean Kurtz's lifetime. So, for example, in 1981, which even, I think, Professor Cook can remember back that far, kind of. In 1981, D.C. sodomy reform was vetoed by Congress, by the House, based upon a holy coalition of white Baptists, black Baptists, who had been at each other's throats often in the Civil Rights Revolution, and Roman Catholics. And Reverend Falwell, a leader of the Baptist groups, warned that God will judge America if it tolerates sodomy. And the same kinds of arguments were made by the Catholics in New York in the 60s, the Baptists in Kansas in 69, Kansas, Texas, etc., and by the Mormons in Idaho in 1972. In the 1980s, and this is not just Reverend Falwell, though he said it, in the 1980s, the Southern Baptist Convention took the official position as a matter of religious faith and the interpretation of the Bible that AIDS is God's judgment on the United States for tolerating homosexuality. Secondly, the civil rights groups challenge to the closet, the Bowers thing, where you can be a lesbian as long as you're closeted and hidden, but once it comes out, then we've got to fire you. So civil rights groups have challenged this closet idea and supported anti-discrimination laws. Much of the opposition, perhaps most of it in some states, has been based upon religious claims that associational expressive liberties are being sacrificed if you adopt these laws. So the opposition to anti-discrimination laws by Catholics in the 80s, Mormons and Baptists in the 90s were religion-based oppositions that we have a constitutional right not to associate, not to be polluted by the presence of openly lesbian or gay people. This was the position of the Boy Scouts, position in Colorado Amendment 2, and so on. And then you see it today in the T-shirt cases, where the claims of the students, the happy not gay student or the homosexuality is shameful student, if you do one of these T-shirts, do the happy not gay, that was allowed. The shameful homosexuals was not allowed. But the one you don't want to do, please don't do the Leviticus one, because the Leviticus one is these people should be put to death. And people who've actually read the Bible might interpret that as an invitation to violence, which is not protected by the First Amendment. So those are those cases. And then the civil rights issue of today, or one of them, is challenges to laws that bar same-sex marriages. And here, among the most powerful arguments, these are not the only arguments, but very powerful arguments that are made in California, South, elsewhere, is the religion-based arguments that parental liberties are being infringed by recognizing same-sex marriage. And the argument that was made in California, I think decisively, to defeat same-sex marriage and to adopt Prop 8, was the argument that if we recognize same-sex marriage in California, parents will lose control
of the normative education of the children. And this was not an unfactual argument. They actually cited a case for this. It was very scholarly. Though you wouldn't get tenure at Yale based on it. It was a very scholarly argument. You wouldn't get tenure here either. And that is Parker and Hurley, which was a Massachusetts case. After same-sex marriage in Massachusetts, it was indeed the case that some school districts then distributed books, Heather Has Two Mommies, and The Prince and the Prince, books like that. And some of the parents objected, said, we don't want our children learning about same-sex couples. We want them to learn that this is degraded and bad and this is not normal marriage, and these books are not doing that. So the parents said, we want at least notice that you're going to be springing this on the children, and we want the chance to withdraw our children from this instruction. The school said no, and the federal courts upheld them. So again, this is religion-based privacy arguments, parental rights. And in California, I think those were the decisive arguments that led to the victory of Prop 8, because it was a very narrow margin. Okay, what lessons might we draw from the parallels? Now, these are not exact parallels. The main difference is, in my opinion, the religious arguments in favor of abolition, integration, and marriage equality for racial couples. I think there were a lot of religious arguments and religious folks and religious leaders on both sides of that. And I will tell you, on the gay rights stuff, there are a lot of religious leaders on the side of gay rights, but it's not as balanced as it was in the race area. I think that's the big difference. But I think there are lessons from the race parallel for current equality-liberty clashes. There are three lessons. Lesson number one, which might be shocking to some of you, and please ask questions about it, denounce it to your friends and on blogs if you disagree, and that is the mutually constitutive relationship between church and state. So forget about the free exercise clause and all that stuff. These are all whatever they are. But the fact of the matter is that church and state in America are mutually constitutive. And I would even expand it to say religion, society, and the state in the following ways. And that is that cultural norms will be translated into religious doctrine. And it's not difficult to do that. The Bible is a very long document. It is filled with lots of general statements that can be cherry-picked, taken out of context, and interpreted in a way that will support all sorts of propositions. So the Bible is very porous in many ways. And remember, tradition also adds to what the Bible has, or maybe subtracts. As cultural norms change, however, religious doctrine will also change. And the stunning thing for me, I didn't realize this, and I think this is true, and your opinion is worth just as much as mine. You don't have to have read all this stuff to have an opinion on this. What was most surprising to me when I read these materials is the way in which the most literalist groups, the ones that take the Bible as the literal word of the Lord unchanging, were the most wildly dynamic. And the most openly evolutive groups, the Roman Catholics and the Jews, which believe in like evolution and interpretation and rabbinical authority and the Pope over, the most evolutive ones are actually the most stable. And I'll give you just one example. I could give you lots of Baptist examples. The Mormons are just like too wonderful for mention. So the Mormons, for most of their history, said African Americans can never be full members of our church. They are degraded. They are a lesser race. They were the Lamites, and then they became otherites, but they're never going to be Mormonites in the full sense of being Mormon. You can be auxiliary members, et cetera, et cetera. And this is the word of the Lord, the whole business, Noah's curse, the whole thing. In 1978, the leader of the Mormon church had a revelation from the Lord that this was wrong. Even though Brigham Young said it, it was Book of Mormon, all this stuff. No, this was wrong. And in 1978, he issued a proclamation, whoops, we was just wrong, and African Americans now fully recognize the word of the Lord is now clear. Okay, right? Cannot get any more dramatic than that. And there are a lot of good examples from other fundamentalist religions. The Mormons are just like almost caricatures of this, etc. So the argument is, obviously, what probably the leader of the Mormon church, not clear, the hypothesis from a law professor would be, well, the word of the Lord was maybe filtered through cultural norms, and it was no longer convenient for the Mormon Church to take openly racist positions, and that this led to a revelation and change in doctrine. But on the other hand, so that's on the one hand. So religion itself, I would suggest to you, is dynamic. And it is dynamic, feeding off of changes in cultural norms and state rules. So I can't resist tell you about the Baptists as well. So the Baptist Church, bigger church. Reverend Falwell, Reverend Criswell, these are two of the big Baptists of the 20th century. Avid segregationists. And indeed, when I think the 64 Act came through, Reverend Falwell set up his own Christian academy, his own segregated Christian academy, so that segregated white parents, racist white parents, could send their segregated children to segregated white schools and not to the public schools, which might be desegregated in Lynchburg, Virginia. Okay, that's Reverend Falwell. Reverend Criswell don't know as much about, because I've actually been to church with Reverend Falwell, know him and all that. Voting Rights Act goes through 1965, 1966, Virginia turns out the segregationists. 1967, Virginia elects the first Republican governor in almost a century, who actually, unprecedented for these people, these governors, actually sends his children to integrated public school. Most of the liberals say desegregation and send their children to basically segregated private schools. Linwood Holton actually sent his children to desegregated public schools, right? Republican. Okay, so in the wake of all that, and once it becomes clear, even Strom Thurmond, not quite your state, but close. Strom Thurmond, big racist, segregationist, but Strom Thurmond starts being very responsive to his black constituents after the Voting Rights Act of 65. He turns on a dime, right? And that's exactly what happens to the word of the Lord for Reverend Falwell and Reverend Criswell. No longer does the word of the Lord mean segregation. Now it means integration, okay. We move on to other issues, soon to be abortion and gay rights. Okay, so that's the argument. But it is mutually constitutive, is my argument. And that is religion feeds into cultural norms, as do state rules and normative discussion. So in other words, I think one of the reasons for the great success of the civil rights movement was the fact that it had religious norms and religious congregations and religious discussion as well as secular. And I think that gave the civil rights movement part of its great power. There's no one thing, but that was part of its great power. And so religion can be both the source of prejudice, can be the repository of prejudice, and an instrument for redemption. And I think it will vary from context to context how the balance between prejudice and redemption plays out in religion. And then I give you some examples. I've already given away my Falwell example, that after these statutes, virtually overnight, the religions abandoned their opposition to integration, et cetera, et cetera. And even in the Bob Jones case, where most of the Southern religious groups supported Bob Jones, because they were afraid of losing their tax exemptions and subsidies. But I've read the briefs in the case, and I believe every brief, amicus brief that's filed in the case at the Supreme Court level by other religious groups, I believe every single brief explicitly disassociates itself from Bob Jones's interpretation of Scripture. And the Presbyterians, that's my group, the Presbyterians actually say that the Bob Jones interpretation is racist, and the Presbyterian Church doesn't agree with it, but they still think they should get the tax exemption from the federal government. Okay, you go figure about that. That's lesson number one. Here's lesson number two, and it's what I call equality practice. Lesson number two is that social change and legal reform, in my opinion, do not stick in our culture until at least some major religions have abandoned their opposition. So that means, for me, an important forum for gay rights is within religion and not just within cultural discourse and state discourse. And that this ought to caution us against excluding religion from gay rights discourse. Now, in 1968, 69, the Metropolitan Community Churches was actually founded for gay people. There's actually churches that were founded. Within the major denominations, including the Catholic denomination, there are openly gay groups that have been interpreting Catholic tradition for 20, 30 years, 40 years maybe, along those lines. There are debates within the Methodists, the Presbyterians, even the Catholic Church, over how far they should go on gay issues. So these are really live debates. And let me give a race example as well, is that I think Brown was not possible until many Southern Catholics, Presbyterians, and Methodists, and some Baptists, openly renounced apartheid as a matter of religion. And not just black Baptists, but white Baptists, white Presbyterians. There was a lot of discourse in the Presbyterian and these other churches in the 40s and 50s. And much of it was hostile from religious points of view to apartheid. And my suggestion, I don't think this is the main thing about Brown, but I think this is one of the important backgrounds about Brown that has been neglected, is the way in which religious discourse within the Southern, formally supportive of segregation religions, there was vigorous opposition to the racist ideology that was reflected. And I think it is remarkable that by 64 to 67, when you get the Civil Rights Act and Loving, even fundamentalist religions in the South were formally renouncing segregationist faith precepts. And again, you see the Reverend Falwell and so on. That's lesson number one. Or lesson number two. The lesson number two example, I think Romer, which many of you have read, that's the Colorado Initiative case, was, I think, a much easier case for the justices because Catholic, mainstream Protestant, and Jewish faiths openly opposed anti-gay discrimination on religious grounds, and they filed briefs. I don't remember the Catholics did, but Jewish denominations, Presbyterians, Methodists, all of these groups filed briefs saying this is antithetical to good religion in America, and we oppose open segregation and discrimination against gay people. I think the Lawrence case, where the Supreme Court overturns Y'all's case, the Bowers case, Lawrence is an example of a Supreme Court decision that is wildly overdetermined. In other words, there were just like too many reasons to count why the Supreme Court, like a right-wing Supreme Court, would be motivated to overturn Bowers and Hardwick by 2003. I think one of the reasons, and maybe not the major one, but one of the reasons, was that virtually all the religion briefs in the case supported sodomy repeal. And so you think, what happened to the Catholics? You know, sodomy is still a crime. Nowhere. Baptists? Nope. Mormons? Surely the Mormons? No, no, and no. No briefs from those traditionalist faiths. Lots of briefs from religious denominations, religious faiths, religious groups that argued that this was an abomination to God, that these sodomy laws were kept on the books. Third lesson, and then that's it. The third lesson is we need to keep the stakes low of these debates. And this is advice for courts. You know, point number one was more of an advice for religions, that you all are dynamic and don't delude yourselves. The second one is advice for gay and lesbian rights groups, the ACLU, etc. The third is advice for the courts. And my advice for the courts is to keep the stakes low. Do not override vigorous normative debate over race and sexuality issues through premature door-closing rules. Religious doctrine often does reflect primordial fears and feelings that need to be nudged rather than shoved by the state when they are widely held. Now, this doesn't mean you shouldn't stand up to them, but it does mean you need to tread very carefully. And here is a case that I was indirectly involved in, which I think is a good model. It was Gay Rights Coalition versus Georgetown. Georgetown's a very prominent Catholic university and Catholic law school. The D.C. Human Rights Act, D.C. is where Georgetown is, bars universities from discriminating because of sexual orientation in providing services to its students. Georgetown University declined, however, to recognize gay and lesbian student groups. Said, we admit gay and lesbian students, great, gay and lesbian, all this, great, 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 but we're not going to officially recognize gay and lesbian student groups because of our Catholic doctrine, and this is a Catholic law school. So how does the D.C. Court of Appeals rule on that? You know, if you're a devout Catholic, you might say, oh, you should uphold Georgetown for free exercise reasons. If you're a gay rights supporter, you should say, you know, force them to recognize the civil rights of gay people. Julia Cooper Mack, a veteran of the civil rights movement, a very wise judge, Julia Cooper Mack has the following resolution. She avoids a needless clash with the free exercise and the First Amendment. She rules first that the statute did not require Georgetown to recognize the gay and lesbian student groups as an official Georgetown group. On the other hand, she says, but the statute does require equal treatment. And the statute actually said equal services and funds. That's the language of the statute. So she says, so the law does require Georgetown to provide services and facilities to the groups on an equal basis, but it's not required to recognize them in a formal way. Now you might think, well, how corrupt is that? You could also say, how Solomonic is that? Because it recognized the integrity of Georgetown's Catholic position and their desire for religious reasons to distance themselves. But at the same time, it recognized the statutory and maybe even constitutional mandate of equal treatment and reached the following resolution. Now, I was professor at Georgetown right after the case was decided. And I can tell you that there was no more supportive. Jay talked about my time in Virginia, where there were lots of homophobic incidents. University of Virginia was a very bad place for a gay person to be in the 1980s. Georgetown was fabulous. Now, the students were not supposed to call themselves the Georgetown Outlaws or whatever the student group name was, but they got facilities, they got funds, they were treated very nicely. When I got there, we even the gay students hosted the Halloween party for the law students. Not a peep out of the archbishop. It was all fine. Catholic Church saved face, the students got to flourish and do all of that stuff. Current example is same-sex marriage. We've seen already what happens when the courts prematurely address the issue. That was Hawaii in 1993, where they said it was a suspect classification, and they were probably going to overturn it. Generated the most ferocious anti-gay backlash, probably of my lifetime. President Clinton's DOMA statute, and so on and so forth. And I think there are several things you all have done here in Georgia. Religions were frankly not ready for gay marriage then. It was a very novel issue, was contrary to a lot of the established doctrine, etc. Now we have had since 1993, had in the new millennium, marriage recognition, marriage equality in New England and California, though again California overturned by initiative, but significantly in both states with a very fair amount of religious support and a lot of religious ambivalence, even within the Catholic Church in New England. Now Perry versus Schwarzenegger, which is the current case that Ted Olson and David Boies have filed out in California under the federal constitution. All these others were state constitutions. I think is premature. It's well premature, particularly at the Supreme Court level. The U.S. Supreme Court will not and should not intervene in that to strike down marriage exclusions all over America, frankly, because the discussion within America is still proceeding. It is not ripe. It is a discussion that is not over, certainly not over in the South, where there might be riots in the street from a U.S. Supreme Court opinion requiring Georgia, for example, to recognize same-sex marriages. And one of the barometers of the discussion, I think, is religion. That a lot of religions that are totally tolerant, very open religions are still in the middle of what they consider a very difficult discussion. And that's one barometer why the discussion shouldn't end through a premature Supreme Court opinion. And that is it. And there will be a much longer, and if you can imagine it, gassier publication, hopefully in your law review. Thank you.